SJC-13563, Jeffrey Frank Cubberley et al. Versus the Commerce Insurance Company.
Okay, Attorney McCullough, whenever you're ready.
Good morning. Thank you, Madam Chief Justice and Associate Justices. May it please the members of the court. I'm Kevin McCullough, and I represent the appellants in this matter. This case is before this court on direct appellate review following the dismissal from the trial court and allowance of the appellee's motion to dismiss. The question in this case, and the issue in this case, is whether Part 4 of the standard 2016 Massachusetts automobile insurance policy provides coverage for inherent diminished value, IDV damages, for third-party claimants. And the answer to that question is that it does. Part 4 of the 2016 policy, as drafted and subsequently approved by the Commissioner of Insurance, does not exclude IDV damages. Moreover, if the Commissioner of Insurance attempted to exclude IDV coverage from Part 4 of the policy...
Is that really true, though? Because this isn't the same as McGilloway. Because we have specific language in this standard form policy that specifically references tangible property. How could that necessarily not exclude IDV damages?
There's two parts to the answer, Your Honor. The first part is, in considering the McGilloway and the track that McGilloway took to get to this court, it's important to consider the timeline of the 2016 policy. The insurance companies were fighting and disputing IDV as covered under Part 4 under the 2008 policy. The 2016 policy was enacted while that same fight was still going on. And the changes that were made and authorized by the Commissioner of Insurance were taking place in an effort to strengthen that fight by the insurance companies. But the 2016 policy was enacted 4 years prior to me standing before this court under the 2008 McGilloway case. And I'd submit to the court that the language in Part 4 of the 2016 policy, and specifically the otherwise required by law language, is intentional. And that is, that answer had not yet been addressed when they drafted the 2016 policy. This is not a situation where the McGilloway case came down and then the changes were made to the 2016 policy subsequent to McGilloway. The track and the timeline of this issue is important here, Your Honor, and that is the when the 2016 policy...
But if I could interrupt you, counsel, why isn't the language the importance? I understand the history may be of some interest if the language were less than clear, but the language says that it only covers tangible property, and then to be even clearer, it says the amount we will pay does not include any decreased value or intangible loss.
The language actually has 3 sentences in that paragraph, Judge,
right,
where
but focusing
they're
on the
inconsistent.
ones that I just read, why isn't that the end of the story?
Because of the words, unless otherwise required by law.
Now, so what law requires inherent diminution in value to be covered?
This policy could have been written the same way that it was, with the exception of otherwise required by law, saying, we're waiting to find out what the McGilloway court does.
But
That's why that language is there.
McGilloway was dealing with a different version of the policy.
McGilloway was dealing with, first and foremost, whether or not diminished value was a recognized and recoverable damage here in Massachusetts. Up until that time, that had never been considered and decided.
Well,
that was part one.
Not as a general matter, within the context of the standard policy at the time. So it isn't apples to apples, because
Correct,
it's very different language.
I'd like to answer the question, and that is the reason why there is coverage under the 2016 policy is because the Commissioner of Insurance has exceeded his authority. There's no dispute from the appellants that the Commissioner of Insurance has authority to oversee the drafting and changing of a policy and allow exclusions. But that authority is not full autonomy. The Commissioner of Insurance must comply and make changes that are consistent with and don't conflict with current statutory law and common law. And in this situation, the Commissioner of Insurance did exceed that authority. And the reason for that is MGL Chapter 90, Section 34O. Every policy of property damage liability insurance shall provide the insurer will pay on behalf of the insured all sums the insured shall become legally obligated to pay as damages because of injury to destruction of
But
property.
that can't mean you pay what, I mean, you have you have policy caps, right? I mean,
do, Judge,
we're
yes.
only going to pay damages up to this amount, right?
Absolutely.
That's not a violation of the I mean, can the insurance commissioner not allow that?
That actually is within the following couple of sentences of what I was reading, is
Go
that
ahead.
the insurance, there are caps and policy limits on the various sections of the policy. That is not an issue.
But the
that we're-
insurance commissioner doesn't require every insurance company to pay all damages for everything, right? I mean,
No, but the insurance commissioner does require, for this case, that the insurance company under Part 4 pay for all damages that may be recoverable in tort up to the applicable policy limit.
Does it say that?
It says legally obligated to pay. I thought that traditionally that was construed to mean under the policy.
It does not,
No?
Judge, no.
I
When we're-
mean, and why not? What does an insurer have to pay other than what's specified under a policy?
What an insurer has to pay is dependent upon which section of the policy we're evaluating here.
Right,
And
but
that's why there is,
the parameters of the obligation are defined by the policy, correct?
correct.
Okay, so why isn't that what legally obligated to pay means?
Because the policy and the provisions flow from the statutory law. And 9034-0 starts out with third-party damages, which would be Part 4, and then it goes into collision and limited collision, which would be Part 7. And
Right, but
that's
it
where
doesn't say anything about the types of damages you're seeking here, these IDF damages.
Well, respectfully, Judge, it does, when it says legally obligated to pay as damages because of injury to or destruction, all sums the insured shall become legally obligated to. And if you look to the 2016 policy, the policy acknowledges that with the second sentence. The amount we will pay is the amount the owner of the property is legally entitled to collect through a court judgment or settlement or for the damaged property. That, by definition, says we're going to cover our policyholder for tort damages that they may cause. Now, this very court in McGilloway has held.
But are you claiming that these damages are tort damages?
Absolutely, Your Honor.
Tort damages to the property?
Yes, Your Honor, and that was decided by this court in McGilloway. The McGilloway court found and held that inherent diminished value is a tort damage. We previously have held that the term property damage can include intangible damage such as the diminution in value of tangible property. That was
That's-
this court in the McGilloway decision.
I see a distinction between diminution in value and tort damages, but it may be a distinction without a difference.
Diminution in value is a component of tort damages. When I say tort damages, and when the policy says they're going to cover their insured for any damages legally entitled to be collected through judgment or settlement, inherent diminished value is a damage that would be pursued in court and recoverable. Putting aside whether or not this court decides that the Part 4 of the 2016 policy covers diminished value, a tort victim in Massachusetts following the McGilloway decision has every right to file a lawsuit against an at-fault driver and seek compensation for the diminished value lost in the car,
Okay,
so long as he
That's not what's
can.
happened here, though. You
That-
didn't, your clients did not sue the insureds,
Correct.
right? Instead, you're proceeding directly against the insurance company on a breach of contract theory.
Correct.
Not a tort theory, a breach of contract theory claim. And the question, I think, is, as a result, what are the contract damages to which you're entitled on that breach of contract claim? And that would be informed, or no, governed by the terms of the insurance policy, no?
Absolutely.
Okay.
Absolutely. We are suing the insurance company as a third-party beneficiary for the insurance contract, the insurance policy. And we are
What is
subject
your
to,
legal authority for that proposition, that you're a third-party beneficiary of the insurance policy? Why don't you have to go get a judgment against the insured first and then reach and apply the insurance, if any?
because in this situation, Your Honor, the appellees have accepted liability for the collision and have already processed the claims. The appellees have made payments to the victims in this case, Cubberley and Seaver, for the property damage to their vehicle. They've started their obligations under that contract owed to the third-party beneficiaries, Seaver and Cubberley. There's partial performance on that contract. In a situation where a third-party beneficiary to a contract interacts with the contracting party, and they start that contract, and they evaluate the claim, they accept liability, and they make payment. The only fight now is, what are the damages that are recoverable? The question of whether or not there's a contract.
Well, there would also be the amount, right?
Exactly.
Right, so why doesn't that, though, support the notion that you would need to go get all of those disputes resolved first in a contract against the insured, have it reduced to a judgment, and then go take that judgment and seek to reach and apply the insurance proceeds to it? Because right now, no one knows what they might be.
The difference here is that the partial performance. And I would agree with the court under the hypothetical that if Mr. Cubberley was in a car accident with a Commerce insured, and Commerce denied liability, or Commerce did not pay for Mr. Cubberley's property damage, we would have to pursue the insurance company directly. But in this situation, the appellee accepted liability for the collision. They acknowledged that there was coverage. They made payment to Mr. Cubberley for some of his damages. And now he's seeking recovery of additional damages. The fight here is not over who's at fault or liability. It's not a fight over the coverage for property damage. It's the components of property damage.
Sure, but we have said that that a third party does not become a third party beneficiary to a contract until they hold the judgment.
That's the Flattery case, Your Honor, and this is not that case.
How do we get around that here?
The fact that there's partial performance on the contract, the fact that Commerce has already made payment to
See, to me,
Mr.
it
Cubberley.
seems that what you're really looking for is a declaratory judgment, not a breach of contract claim, a declaratory judgment as to the meaning or the scope of the insurance policy, whether the insurance policy covers these IDF damages.
You're exactly right, Your Honor. And
Okay.
that was exactly the issue before this court in May of 2021 under the same theory of a breach of contract. And the argument was under the policy language of Part 4 of the 2008 policy. This is that same exact case, except it's the language in the 2016 policy, which had been enacted 4 years prior to the McGilloway decision. So the mechanism that brings us here today is the same mechanism that brought us here in the McGilloway case, and it's the same claim and the same type of claim where there was acceptance of liability, there was a processing of a claim and partial payment of the claim.
So let's just go to the end then. If you agree with me that what you're really seeking is, in this suit, is a form of declaration as opposed to contract damages, but a form of declaration as to the meaning of the contract, then are you actually pursuing in this case in this appeal, the breach of contract claim, or are you pursuing the declaratory judgment claim?
We are pursuing the breach of contract claim. We're not pursuing the declaratory judgment claim with this case. We're here because the language in
So what would be the relief?
the relief would be a ruling that the Commissioner of Insurance has exceeded his authority when he enacted and approved exclusions in the policy that were inconsistent and directly in conflict with MGL Chapter 9034-0 and the McGilloway decision.
Okay, there would be no damages awarded in this case.
if I win at this level, the case will be remanded and we will seek to prove those
You're
damages
just-
at the trial court.
Okay. To my mind, you're only seeking a declaration.
We're seeking the inherent diminished value damage, money damages that are being denied based upon a portion of the policy that the appellants believe has gone too far with the Commissioner of Insurance. The terms and wording that were added to the 2016 policy, when they use terms like we won't pay for intangible property, we won't pay for loss in value, those intangible damage and inherent diminished value damages are recognized tort damages. This court held that. So the fact that Chapter 9034-0 requires the policy to cover and indemnify the insured and pay a tort victim's tort damages, that's why we're here,
It
Judge.
says up to 5,000. So
That's the
it's not
compulsory
going to
limit.
be everything, and then you acknowledge that the commissioner can include exclusions. Why can't the commissioner exclude inherent diminished value?
Because of Chapter 9034-0, it says that you can't, and it's up to 5,000, but that 5,000 is the compulsory limit.
Is there a case, can you cite one case where an insurance commissioner has granted a similar kind of exclusion and that was found to be a violation of their authority? Because there are no cases in your brief, as far as I can tell, making that point.
Yeah, there actually are, Judge, and it's
Which one?
this court.
Because your brother's going to stand up and argue that it's standard for the insurance commissioner to allow exclusions. That's what you bought. And you can, so I would just like a case that goes the other way that I can look at so that I can say, oh, that was an ultra virus exclusion.
Yeah,
Sure, there are some, but you don't cite any, so we're going to have to go back and do it
there are,
ourselves.
Judge, and I don't have a case site for that in front of me. But the issue of the insurance commissioner can enact exclusions and policy limitations, that's not the fight that the appellants have. It's when those exclusions conflict with the statutes and the common law here in Massachusetts.
You're just overreading that sentence there that says, consistent with law, but there are permissible exclusions allowed, all kinds of permissible exclusions. So I just don't get what you're arguing.
There are permissible exclusions, like authorized use. Who's going to use the vehicle, and when will we provide coverage? What will the vehicle be used for? Exclusions on business or livery. Those are exclusions. But when there are exclusions that limit or reduce the statutory damages, I think it's very important that when the court
Counselor, you keep going back to the statutory part, and I still struggle with this because the term in the McGilloway Part 4 was broader than in Part 4 of the 2016. In McGilloway, the term just said property damage. And so it would subsume the IDV values, which is why we came out the way we came out. But this is different because the language you point to is sandwiched in the paragraph that starts off by saying, we only cover tangible property, and it ends the paragraph by saying, we don't cover intangible stuff like this. So how do we get around that? If we go back to Justice Wolohojan's point, where this is tethered to the terms in the recovery under the contract. So we're talking about very different contract language.
I appreciate the question, and I think, Judge, the ultimate question and language to be evaluated here is that second paragraph in Chapter 9034-0. And if this court finds that intangible damage is not by definition a recoverable damage under the policy, we lose.
Okay.
If this court finds that a decrease in value to a vehicle following a collision is not the type of damage as defined within the second paragraph of 34-0, we lose. What I'm saying to this court is the wording of the second paragraph in 34O, and when it says, all sums an insured shall become legally obligated to pay, if I go to court today on behalf of a client seeking intangible damage or diminished value damages, I can recover that. There's nothing stopping me from recovering that. So if this court finds that...
From the insured?
From the insured.
Sure, but that's a different question from whether you can recover it from the insurer.
Understood. I was making the first point to get to my second point, which is there's no case law in Massachusetts that defines an intangible damage or diminution in value as not covered under the language of 34O.
And with that, I'm going to say
Thank
thank you. Okay, Attorney Apjon.
May it please the court, Nelson Apjon for the Applee Commerce Insurance Company. With me this morning is my partner, Eric Magnuson. I'm actually going to reverse things as to what I was going to start. I'm going to start with 34O because there was a fair amount of time spent on that. And what was left out of that argument, plaintiff focused a lot with respect to the second paragraph of 34O. And 34O is set forth on page 25 of our brief. I direct the court's attention to the first paragraph of 34O and the final sentence, which is not mentioned on oral argument, it's not mentioned in the briefing, but it's mentioned in our briefing. And the final sentence defines what property damage liability insurance is under the statute. And it says that property damage liability insurance is insurance containing provisions as prescribed by this section, 34O, among such other provisions, including conditions, exclusions, and limitations as the commissioner may approve. So by definition, property damage liability insurance includes the conditions, limitations, and exclusions approved by the commissioner. There were 3 trial courts that looked at this language, plus the First Circuit, Judge Kanzenzian below, Judge Casper and Judge Burroughs in the federal court all decided that the language under 34O permitted the exclusion here, as did the First Circuit, and the plaintiffs don't deal with that at all. That gives explicit permission to define property damage liability insurance to include exclusions. And I note that there are at least 8 other exclusions in Part 4 in its entirety that are part of Part 4. So it's nothing unusual to have an exclusion by the commissioner with respect to the coverage of Part 4. And that brings me back to the first argument, which is...
Before you leave 34O,
Yes.
I take it there are times, although not cited in your brother's brief, where the exclusions are impermissible, right? There are cases where certain exclusions are not allowed, right?
I'm not aware of it applying to exclusion. I know the general agency principle that if it's unreasonable or arbitrary, it will not be upheld. But of course, with respect to the interpretations of the statute, deference, although it's not controlling, is typically given to the Commissioner of Insurance with respect to the relevant statutes. But I'm not aware of a specific exclusion being found to be unreasonable or arbitrary.
Have we had any cases where we've concluded that the commissioner acted ultra vires as with respect to the last sentence of the first paragraph of Section 34O?
I'm not aware of any, Your Honor. But with respect to Part 4, I think there was, during the course of the argument, there was an intermingling of the word damage and damages, and I think that words are important. Part 4 of the policy is quoted on page 18 of our brief. On page 22, there's a chart comparing the difference in language between 2016 and 2008. And the initial sentence was changed to, "We will pay for damage or destruction to tangible property." The trial court below focused on that language to distinguish the 2016 policy from the 2008 policy. And as Justice Georges suggested, if we go to Judge Casper's opinion in the Morello case, which is in our addendum, she points to that as well. She says the 2016 coverage is limited to damage or destruction of tangible property, whereas the 2008 policy broadly states that third-party coverage includes paying damages to someone else whose auto or property is damaged in an accident. Again, this point was ignored by the plaintiff with respect to the briefing, and I think an oral argument as well. So Part 4 clearly excludes recovery with respect to inherent diminished value claims, and that is termed to be an intangible loss in the McGilloway case. And unless otherwise required by law, not argued in oral argument, the plaintiff or the appellant in his brief suggests that it applies to common law. It doesn't apply to common law. It applies to statutes and regulations that govern what an insurance policy has to contain. And the reason for that is if you say it applies to common law, as was suggested, the exclusion is meaningless, because if the intangible loss is not recoverable at common law, there's no reason for an exclusion. The exclusion has to kick in where it's recoverable at common law, but it's excluded under the policy. And of course, there's a familiar contract interpretation rule that every word and phrase of a contract should be given meaning and none should be treated as surplusage if any other construction is rationally possible. The argument of Cubberley and Seaver ignores that principle altogether. We talked about 34.0, and there was a statement during oral argument that Commerce admitted to liability. That is incorrect. Commerce specifically denied liability in its 93A response to the plaintiff or to the appellant. And that response letter was referred to in the second amended complaint in paragraph 104, and where the general conclusions of a complaint are contradicted or inconsistent with the document incorporated by reference in a complaint, it's the specific language of the document that controls, not the general conclusions. And that's from a Ninth Circuit case, Finnegan Holdings. But of course, the construction given to the Massachusetts rules will be the same as the federal rules, absent a significant difference in content or significant reasons to the contrary. There's also an independent ground to uphold the dismissal of the complaint in this case. And the argument was raised below but not reached by the trial court given the contract interpretation. And that was the point is that there is no judgment here against the insured. And the motion to dismiss, of course, can be upheld by this court on any ground, even if not considered by the trial court. Other than in Chapter 93A, there is no direct right of action against a third-party claimant. There is no direct right of action by a third-party claimant against an insurance company absent a valid judgment against the insured.
I'm sorry, counsel, just remind me, did you raise that issue in McGilloway?
No, Your Honor.
Okay.
No.
How do you want us to deal with this now? So we've taken the case. There's an important issue out there, which is the legality of the insurance commissioner's standard language, but we have no judgment. What do you want us to do?
What I would like to do is win on appeal.
Okay.
On the merits?
Very bold.
Put it straight.
Okay.
That's very strange.
Yes, I know.
Most people
But
come here wanting to lose on appeal.
Either ground I would be happy with. But there is no independent right of an action against the insured.
You don't care if this is clarified or not.
As I said, either ground would support a dismissal.
Would you
as well as
need a
both.
prior judgment if, because there are a couple different claims. There's the breach of contract claim, there's a Chapter 93, Chapter 176D claim, although they're not raising any argument on appeal about those.
That's correct.
And then there's the declaratory judgment claim. Do you have a view on whether a prior judgment is necessary to pursue the declaratory judgment claim?
Yes, because if a complaint fails to state a claim upon which relief can be granted, the trial court is empowered to dismiss the declaratory judgment count as well. And of course, there was no appeal from that dismissal in the lower court, so it's been waived, as I think, under the rules of this court if you don't raise it and argue it in your brief. So that's been waived already with respect to the declaratory judgment. As to 93A, we are not contending that there's no direct right of action against the insurance company under 93A. There is by statutory. My argument only
Right,
goes
so
to
then,
contract.
right, so then if it were 93A, we could still, I don't know how this would work, I'm just spinning things out here, which maybe I shouldn't do right from the bench, but the issue under 93A might still require an interpretation of the policy language?
It would, because there would be no duty to settle a case where there was no underlying liability.
Exactly, so it could just come in through there.
Yes, and I would say the dismissal of the 93A counts also were not appealed from the judgment below.
So
we're really only dealing with the contract claim
Yeah.
here. And that does require a direct right of act, or a judgment against the insured. And the court held that in the Rogan case in 1940. That's been termed to be black letter law in Massachusetts since 1940. The court interpreted the two statutes, Chapter 175, Sections 112 and 113, as a legislative mechanism for pursuing an insurance company directly, and both statutes require a judgment against the insured. As to this third-party beneficiary, the Flattery case, which was mentioned by the appellant, that case specifically said applied to a third-party judgment holder having a third-party beneficiary right with respect to the contract. But again, that was a judgment holder in that case, and that's not the situation here. You still need a judgment even under the third-party beneficiary rule.
So just to clarify, the only claim that was appealed was the breach of contract?
That's correct, Your Honor.
Thank you.
And I would say there's no reason to change that, and this was, of course, also looked at by the First Circuit, and the judge, we heard about partial performance, but as Judge Saylor said in the Martins versus Bront mutual case, he said, there's a big difference between an insurance company routinely paying a third-party claim based on an assessment of their insured's liability, as opposed to conceding liability or conclusively establishing the insured's liability and the scope of that liability by simply making a settlement offer.
I'm sorry to go back to this again. When you say the only thing they've appealed is the breach of contract claim, that's not based on the notice of appeal, is it? It's
No,
based on the fact of appellate waiver?
The briefing, Your Honor, yes.
The appellate waiver,
Yes.
okay.
And going back again to that principle with respect to paying a portion of a claim, that's not an admission of liability. The First Circuit recognized there's obvious difference between being obligated to make a settlement payment or a settlement offer and somehow conceding that your insured is liable for everything with an unlimited scope. In fact, in Massachusetts, it would put the insurance company really in an untenable position because between 93A and 176D, the insurance company has an obligation where liability is reasonably clear to make a prompt, fair, and equitable settlement offer to the plaintiff. And by doing that, by complying with the statute, doesn't mean you agree to every claim that arises out of an accident. You know, think of a slip and fall case. You pay the medical expenses, there's no argument over that. The next thing you know, there's a claim for a permanent impairment. Those are two different things. You deal with one claim at a time. In fact, 176D really requires you to deal with one claim at a time in a sense. If something is reasonably clear liability-wise, it's something that needs to be paid. Or something that at least a settlement offer has to be made. Now, as you suggest, if there's going to be a change to mass law, and that is something, given the statutes in Massachusetts under 175, 112, and Section 113, it really is something that should be left to the legislature. As far as the 93A claim and the declaratory judgment, I'll simply rest on our brief on that. They were not raised before this court, but there's also independent reasons why the 93A claim would not survive, because I believe, as we suggested, we're correct with respect to the contract interpretation. That certainly is a plausible interpretation. 3 trial courts have upheld it. The First Circuit has upheld it. So what I'll do is conclude there and say we ask that you enter an affirmance of the judgment below, and I thank you for your time.